Today we've got a distinguished NARF alumnus with us and two current NARF staff attorneys. So I would like to introduce first Suzanne Schoen-Harjo, president of the Morningstar Institute and NARF alumnus. To her immediate left is Matthew Campbell, our staff attorney from the Native American Rights Fund, and to my immediate left, Heather Whiteman runs him, also a NARF staff attorney, and both Matt and Heather are out of our Boulder office. So with that, I'd like to turn the microphone over to Suzanne to give you a little bit of a background as to how the Native American Rights Fund started. But before I do that, let me introduce myself. I'm Don Ragona. I am the Assistant Director of Development and House Counsel for the Native American Rights Fund, also out of Boulder. So again, I'd like to turn this over to Suzanne to talk a little bit about how NARF got its start, why it started, and how we wound up in Boulder, and how we basically set our focus on parameters on how we choose the kind of cases that we work on behalf of Indian country. Suzanne?
Thank you. I'm so happy to be here to lift up Native American Rights Fund, which has done so much good in Indian country, especially in the priority areas. Several lawyers who were working for California Indian Legal Services began Native American Rights Fund, and one of those was John Echohawk, who's the current director. So all this time he's been director since the 70s, and Ford Foundation had indicated throughout the United States that they wanted to fund non-white legal operations that were nonprofit, and one that they were doing was the NAACP fund. Another was MALDEF, the Mexican American Legal Defense Fund, and they were very interested in doing a Native legal operation and organization, and so they funded Native American Rights Fund, and it was founded by a steering committee and by those California Indian Legal Services attorneys and Native attorneys who were pups. They were the young Turks. And I was at the National Congress of American Indians. Well, I was in New York as working at WBAI Radio when NARF started, and I went to the very first Ford Foundation reception to announce their partnership with Native American Rights Fund, and that was so exciting. And then when I moved to Washington, which was a big surprise to me, I went as news director for American Indian Press Association, and my beat was Washington and how Indian law is made. And one thing I saw right away was that there were no Native people making Indian law. Well, no wonder we're in the shape we are in. And so I was doubly impressed that Native American Rights Fund was up and running and really doing things that were needed in Indian country. Not that people told us we needed, but that they needed. That they identified for themselves. And they began with a steering committee of traditional Native leaders and practitioners from around Indian country, and very important, stunningly important group of people, very dedicated, committed, and very aware of who their peoples were and who they were accountable to. And they set some priorities, and I'm going to read these, and the way cases are chosen is they have to fit within these priorities. And the priorities really haven't changed. Preservation of tribal existence, protection of tribal natural resources, promotion of Native American human rights, accountability of governments to Native Americans, development of Indian law, and educating the public about Indian rights, laws, and issues. So I very quickly, once in Washington, went over the edge from journalism to advocacy, and I worked for the National Congress of American Indians as the legislative director and the communications director, and I worked closely with Native American Rights Fund, and the lawyers for NCAI were supportive of our idea, our general idea, to start a National Indian Litigation Committee to try to avoid taking some cases that were real losers to the Supreme Court and really getting behind some cases that needed to go to the Supreme Court. So the lawyers for the non-Indian law firm for NCAI said no Indian lawyers can serve on this. I said, what? And they said, well, no Indian lawyers are seasoned enough. They haven't been working in the federal Indian bar. I said, well, who do you think the federal Indian bar is? We are. And they announced themselves, and they were all non-native people. Well, I shouldn't be delicate. They were all white lawyers, and they insisted on NARF not being represented, the American Indian Law Center and the American Indian Lawyer Training Program. So what we did was we came up with a compromise, which was that the organizations became supportive organizations to the National Indian Litigation Committee. And the then director of NCAI was not going to give an inch because the lawyers, his lawyers, the NCAI lawyers had said, we'll call your debt up if you insist on putting these Indians on the National Indian Litigation Committee, which was tribal leaders and lawyers. So, and the debt was something that NCAI could not afford to pay, and they were serious, and serious enough for the director to say, okay, we can't have them on it. And the people at NARF went ballistic and said, you can't do this to us. We're the people who are really defining and redefining Native rights and how you exercise those and assert them. So I was so impressed with that I made an agreement with both John Eckelhawk and Tom Fredericks, who was the then director, to go there and work, to be in Washington and work as a legislative assistant, legislative liaison, a white word for lobbyist, and it was quite the education for me, and I was happy to be able to put my, albeit limited, knowledge and advocacy behind some of the things that the steering committee was defining and that the Native lawyers and non-Native lawyers were working on in these important priority areas. And one after one after one, cases were won by NARF, and some important cases were brought even though it was predicted that they would not win, but they were brought because they promoted human rights or they promoted something that had to be promoted. You couldn't let it go by, or there was no way of getting out of the case. That the Nation X or Group X had been sued. And the question was, do you get behind them or not? And the very important decisions. It likes Marcus's beadwork. The very important case of Julia Martinez and whether or not her children could have HUD housing was something that was taken through. Santa Clara Pueblo said, no, only we can decide who gets to be a Santa Clara Pueblo person. HUD housing does not get to decide. The agency HUD does not get to decide. And here was poor Julia and her kids caught in the middle, but they weren't citizens of Santa Clara Pueblo. It was a very difficult and emotional case. And what was decided through this National Indian Litigation Committee and meetings at the Native American Rights Fund was that you had to stand for Native sovereignty, for tribal sovereignty, and to back the notion that only Native nations themselves can define who their citizens are. And that was an important case that Santa Clara won. But part of it was talking it out, and there were several days of very emotional meetings about what's the right and proper and best thing to do. And everyone decided to do it that way, and it was a winning case. And that was due to the expertise and the patience and the diplomacy of NARF. And I was very proud of what had been done there, even though, of course, all of us had so much sympathy for the Martinez family. So those are just some of the things about the early days, and I was not a founder, I was an observer, as I've indicated. And then I jumped into the fray and was happy to be legislative liaison before and after I served roughly in that same kind of position as a political appointee in the Carter administration. And I enjoyed going back to NARF after that. So I'm a 5.5-year alum of Native American Rights Fund and very proud of it. Thank you.
Thank you, Suzanne.